Derek Chauvin back in the news because there are some interesting things happening in his case. And we have been following this along for some time. If you've been part of the channel, you know we spent basically every day here going through the ups and the downs of the trial. And back during the pre-trial phase, before trial ever started, there was a question about whether the prosecutors here or somebody in the government leaked some information about a plea deal that was being negotiated in Derek Chauvin's case, sent that out to the New York Times or to some other people in the media. Now, this is a pretty big problem. If you're a defense attorney and you're representing somebody charged with a crime, well, you're going to be standing by their innocence, right? We have the presumption of innocence in this country. Very important concept. And if it comes out that your client is potentially wanting to take a plea deal, well, that sort of indicates that maybe they are in fact guilty, and we are supposed to presume that they are innocent. So it's sort of not appropriate for the prosecution to be sending out to everybody, hey, Derek Chauvin's here. He said he's going to take a plea deal. We told you he did it, and he said he's going to agree that he did it through this plea deal. It sort of shatters the facade of the presumption of innocence in a very significant and substantial way. And the indication back in February was that there was a deal that was being negotiated. And recall that the allegation was that this was sort of floated up to Bill Barr, who back at the time was the attorney general under Trump. And recall, all of this happened under the Trump administration, and the trial didn't take place until the transition into the Biden administration. So there was this allegation that William Barr, the Attorney General of the United States, was brought in to facilitate some negotiations about a plea deal so that they could deal with any of the federal charges that were going to be stacked on top of the state charges in the Chauvin case. And nobody really knew what happened. But apparently, Bill Barr put the kibosh on that deal, so we're not going to allow that to happen. So then that goes back to the prosecutors. It gets leaked out, and it turns into a big problem because the other co-defendants, not only Derek Chauvin says, well, hey, this might be an issue because now in the news, in the media, in Minneapolis, around here locally, there's a story that's running in the Star Tribune that says that I was going to take a plea deal. Well, if other jurors see that, then they're knowing that maybe I do in fact think that I'm guilty, and it just shatters that presumption of innocence facade that is so important. So you understand that. Now, here, what we're going to see is that the other co-defendants, we have Thao, King, and Lane, they're also concerned about this. They're saying, well, if they're talking about Derek Chauvin and him taking a plea deal, well, that jeopardizes our cases as well, because they're saying that we aided and abetted him in his crime. So if he's going to plead guilty to a crime, then that sort of implicates us, because we can't aid and abet somebody who didn't commit a crime. If he agrees he did commit a crime, well, now it's open that we did aid and abet him. So they filed a bunch of motions saying this is totally inappropriate. I don't know. We don't know who leaked this, but highly inappropriate. We want to get to the bottom of it. In fact, Thao's attorney was saying that they want sanctions and they want a dismissal of the charges as the sanction. They want to say, we want to punish the prosecutors because this conduct is so reprehensible. The only remedy here is to dismiss the charges and then sanction the prosecutors. So it's a big ask. And so the question has been, what happened here? You know, where did this information come from? Who leaked this? How did the New York Times get it? And some people might be saying, well, it's just a little bit of information. No, we're going to go through it. You're going to see the New York Times sounds like they had the entire appeal from the prosecution before it was filed, if I'm reading this right. We're going to read this again, and we'll take a look at it. But let's go over to and get some background from lawandcrime.com. I want to show you this article. It says that Minnesota's outdated ethics rules might allow insiders to smear Derek Chauvin's shot at a fair trial without facing consequences. Okay, so this article is really focused on the ethical rules. They do a whole analysis on the bar rules and confidentiality and disclosure and candidness and all this stuff to the court. Got it. That's kind of irrelevant. The point here is that this is the background of what happened. The plea deal was sort of being, let's go into the article here, because this will explain it better than I can. A major leak in the case against Derek Chauvin. And recall, this happened back on February 17th. This article was written back in this day. So rewind the clock in your mind a little bit. Before the trial even started, it says this: there was a major leak in the Derek Chauvin case. One of 4 former Minneapolis police officers accused of acting in concert to murder George Floyd. This highlights several important gaps in 2 of Minnesota ethics rules, which would otherwise govern the behavior of the leakers. So if the prosecution leaked this, then there are some ethical rules that should govern this. But this article is saying, well, there are rules there, but they can kind of violate but they actually don't apply. So they don't have to follow the rules because the rules aren't on point. The leak, according to a recent New York Times report, was that lead defendant Derek Chauvin stood poised to plead guilty to third-degree murder. Former U.S. Attorney General Bill Barr, the report said, stepped in and killed the deal. 3 anonymous, quote, law enforcement officials reportedly provided the information. Their identities are unknown. So who are those people? And how did they get information about a plea deal that was being negotiated by the prosecutors? And why did they disclose it to the New York Times? Attorneys representing the 3 officers, Thao, Kang, and Lane, have asked a judge to punish the prosecutors for overseeing their respective cases on account of the leak. And during that time, I think we talked about this back here on that on this channel. May or may not have, but a lot of motions were flying back and forth from all the different co-defendants. And I think we talked about this, but from the motion, it says here from Thao's motion, it is impossible to overstate the magnitude of this misconduct or its prejudicial effect on defendants' constitutional due process rights of a fair trial. If this leak would have happened during trial, the court would be required to declare a mistrial and dismiss the charges with prejudice, meaning they can't come back. Leaking a soured plea agreement has no benefit for Mr. Thao, nor does it benefit any other defendant. The leaked information guarantees that any potential juror who read the article or headlines now knows Mr. Chauvin was allegedly ready to plead guilty to murder and accept responsibility in the death of George Floyd. Logically, the only actor that would benefit from this leak is the state, right? And it makes sense because if you're Derek Chauvin, the last thing that you want to do is say, yeah, I mean, go into a trial, say, well, I know that they have to prove that I'm guilty beyond a reasonable doubt, but you're on the third-degree murder charge, you already got me. I agree with you on that one. What's the point, right? That's you would take a plea deal. If you're going to plead guilty, you're going to take a plea deal. And when you're negotiating with prosecutors, right, they can't talk about this stuff. So the government could not have come in and told the jury, let's say that Eric Nelson puts up a defendant or puts up an expert witness, doctor, whatever, puts him up, and he says, based on my medical expertise and my analysis, I have concluded with a degree of medical certainty beyond a reasonable doubt, whatever, that Derek Chauvin didn't, put his knee on his neck to kill George Floyd. And if the prosecutor came back in and said, well, during our negotiations, Derek Chauvin said that he was going to agree that he would plead guilty to third-degree murder. And so that means that he did do it. Isn't that true, sir? Right? Or something like that, right? That would never be allowed to happen because now they're talking about the negotiations to sort of prove that somebody did something. And what you want to do is keep the negotiations open and confidential and basically free of being used against you so that you can, in fact, negotiate. If anything you say during the negotiation process is going to be used against you, you're not going to negotiate. You're just going to be silent like you would so that nothing is used against you. So we want open and free, dialogues and conversations for all of this stuff, but it doesn't serve Derek Chauvin to acknowledge that he did something wrong. He would never make that acknowledgement. Now, here is the motion from Thao. Says that he filed this notice of motion and a motion for dismissal and to sanction Keith Ellison, Matthew Frank, and Neil Katyal. So Keith Ellison, of course, the Attorney General. Matthew Frank was one of the lead prosecutors, and then Neil Katyal was one of the prosecutors that we heard about in the early portion of the trial, but I think it was mostly for the motions practice, the motions in limine. Didn't see him much during the testimony that came out, but you can see here, yeah, they filed this whole motion, 4th Judicial District, notice of the motion. And then what was kind of most important, this was the backdrop here. So this is the framework, right? They said, hey, somebody from the prosecution leaked this. This was all happening back in February. Take a look. This right around the same time, February 15th at about noon. They said, government leaked something they should not have leaked. It violated our defendants' constitutional rights. It was so grossly improper that we're asking for a dismissal of the charges. We're asking for sanctions for Keith Ellison, Matt Frank, and Neil Katyal. And additionally, we want repercussions. I mean, we want a vengeance for this because it was so bad. Now, it was very quiet for a long period of time. We had the trial. We now had a continuance in Thao's case and the other 2 co-defendants. And it all got extended. And so many people have been wondering, well, what about that issue? And what about the no change of venue? And what's going on with the appeals? And what's going on all this stuff? Well, today we saw there was some new activity in court. So you'll notice that I took a screenshot of this earlier. So a couple days ago, we have May 20th, or May 17th, we had 2 affidavits that were filed. We have the affidavit of Voss and we have the affidavit of Nelson. And the affidavit of Eric Nelson, again, was modified up here. So we're going to be looking at this document here from May 20th. right? So we have 3 affidavits filed over the last 3 or 4 days, which is curious. I'm thinking, that's interesting. Why is the defense attorney filing an affidavit in this case? Is the court asking him to sort of swear under oath that he did something or didn't do something? Because I've been looking through the case history, don't see any affidavits that have been filed from the prosecutors. So what's going on here? Well, if we open it up, we're going to see here the first affidavit is from Amy E. Voss. Here's a picture from the trial. This is Amy Voss. Remember her? And it's kind of one of the only pictures where we can see her face. They were masked up most of the rest of the trial. This was, I think, early in the trial. So this is her affidavit. So affidavit of Amy E. Voss in the state of Minnesota versus Derek Chauvin. Let's go and take a look at it. She says, being duly sworn, here's what I state. I'm an attorney licensed in Minnesota. I'm assisting Eric Nelson, Derek Chauvin's attorney in the above case. She says, on February 10th, there was a New York Times article published, Why William Barr Rejected a Plea Deal in the George Floyd Killing. Then on February 11th, the Star Tribune in Minneapolis published the same article, or a version of that. Officials, Chauvin was ready to plead third-degree murder. So it sounds like Star Tribune maybe picked up the New York Times article, revised it a little bit, and then publishes that in the local community, right? But this is before the jury is seated, so they're publishing this. Derek Chauvin's going to agree to plead guilty. And the Star Tribune, one of the biggest newspapers in the whole vicinity. In fact, they covered the trial very well. We were relying on a lot of their reporting. They were one of the only, I think, news agencies that had direct access into the courtroom or something, right? They were one of the premier reporting agencies. So they disclose, they communicate to everybody in Minneapolis that Derek Chauvin is he's on the verge of thinking he was going to do it. He was going to plead guilty to this thing. We could have avoided the trial. But fortunately, Bill Barr said no. Spread that all over the place. In the 2 articles, according to Ms. Voss, it was reported that someone with direct knowledge of the plea deals told the press that Chauvin was ready to accept a deal for his role in the death of George Floyd. She says that here, subsection 6, I was not the source of the information to either paper, and I do not have knowledge about the identity of the source of such information. Further, your affiant saith not, signed here on March 2nd by Amy Voss. Right, and so this was filed today. Here, this was filed on the 17th, the affidavit of Amy Voss, signed off on several months ago. Interesting. Then we have Eric Nelson's. So here is Eric Nelson, affidavit of Eric J. Nelson, and he also submitted one today. Of course, we all know who he is. He says, I am also an attorney licensed to practice law. I represent Derek Chauvin. On or about Wednesday, January 27th, I received an email from Timothy Arango where he identifies himself as a reporter for the New York Times. Mr. Arango indicates that he would be in town for a few days. Asked me to meet for an off-the-record chat. See Exhibit 1, which is the email. We're going to read it. I responded to Mr. Arango. I said, I'm not commenting on or off the record about this matter. That was on January 27th. He fires right back, not commenting. January 28th, then, at 12 p.m., I received a call from Mr. Earl Gray, the attorney for Thomas Lane. We have 2 defense attorneys now who are sort of comparing notes, right? They're working on they're defending co-defendants, so they're communicating. Earl Gray calls. He says, hey, I just met with a New York Times reporter. That reporter had a copy of the state's pre-trial appeal. Mr. Gray, who is Lane's attorney, told me he read the document. He learned that the state was appealing the district court's denial of its continuance motion. And lo and behold, look at this. It was filed at some point that afternoon. So it sounds like the defense. So here's what happens. The New York Times guy calls Eric Nelson, sends an email to Eric Nelson. Hey, you want to meet up? He says, no, I'm not commenting on it. He goes, all right, fine. Let me go talk to Lane's attorney. Goes to Lane's attorney. Lane's attorney says, yeah, I'll meet you. So they go out to coffee. They meet at a Starbucks. They both get a croissant, whatever. And they're having a conversation about this. Arango, the New York Times reporter, says, what's your response to the state's appealing the denial of the continuance? Mr. Gray goes, the hell are you talking about? What are you appealing what? Arango goes, oh, well, I just left the prosecutor's office. I got the appeal right here. So he hands it over to Mr. Lane. Mr. Gray. Mr. Gray then reads it. He goes, yeah, you're right. This is the appeal. Goes back to his office, looks at the court docket. Lo and behold, the appeal was filed that afternoon. So it's going to be public record anyways. So this reporter is just like rolling in and out of the prosecution's office, just getting access to whatever they want. And before it's filed, from this is a signed document, okay? It says, he informed me that he had read the document, learned that the state was appealing the denial of its continuance motion, and then it was to be filed at some point that afternoon. And then at approximately 3 p.m., guess what? They did, in fact, file the first appeal to the Minnesota Court of Appeals. So the New York Times reporter had the inside scoop on what happened. On or about February 10th then, so a couple weeks later, I received another email from Mr. Arango. Mr. Arango stated in his email that he learned that Mr. Chauvin had agreed to plead to third-degree murder, which would have resulted in more than 10 years in prison. But at the last minute, Attorney General Barr backed away. So he gets that email. Eric Nelson shows up in his inbox. The email went on to provide additional information about the plea negotiations between Chauvin's prior attorney and the federal government. Exhibit 1, we're going to read it. On or about February 10th then, immediately after receiving Mr. Arango's email, I responded, quote, "Thanks for checking. I'm not commenting on any aspect of this matter." Later that same day, New York Times then published an article, "Why William Barr Rejected a Plea Deal in the George Floyd Killing." The following day, Star Tribune published an article titled, "Officials, Chauvin was ready to plead to third-degree murder." In these two articles, the court is aware Mr. Arango cites sources with direct knowledge of the plea negotiations and outlines various aspects of the plea negotiations. So where, oh where, did Mr. Arango get it? Well, let's see. He's got an email here. We're going to wrap up. Here's Nelson's final line. He also signed this back on March 2nd. Okay, months ago. They knew this was coming. He said, "I am not the source of the information in the above reference articles. I do not know the identity of the information, of the source of the information. Further, your affiant saith not." Again, March 2nd. Many months ago, right after the February stuff. February 10th comes, signed, notarized, months ago. Then filed today. Now let's take a look at the emails that Mr. Nelson included. And I think I have this in the right order. Yes, I do. So let's go, as we know how emails work, let's start down here. We've got November 5th, 2020. Remember, George Floyd died May 2020. So November comes around, and this New York Times reporter sends an email to Mr. Nelson, says, "Eric, by way of introduction, my name is Tim. I'm a reporter of the New York Times. I'm going to be part of the team covering the Chauvin trial. Today I was reaching out to see if you had any comment on the judge's rulings today. Here's my number. Thanks much." Right, we're going to get rid of those numbers. "I hope that this note finds you healthy and well. I am reaching out." I missed this one. Eric responds, says, "I am not commenting on the case at this time. Thanks for checking." So then we fast forward about 3 months, November, December, 2 months, January 27th. And we have another email from the New York Times reporter over to Eric. He says, "Eric, hope this note finds you healthy and well. I'm reaching out because, as I said in a previous email, I'm going to be covering the Chauvin trial for the Times. I am in Minneapolis for a few days. Want to see if you'd be willing to meet for an off-the-record chat, basically so I can introduce myself. Just let me know. I can be reached anytime. Here's my number." Then what do we get? We get another response. So Eric Nelson responds back, and then we get another email coming on February 10th. From Eric, to Eric from Tim. So the New York Times reporter sending an email to Eric Nelson. And this is where we get some information about the plea deal. So the question that we're asking ourselves really here is, how does this guy get this information? Right? Plea deal negotiations, it's very intimate. It's private. That stuff is extremely confidential for these reasons. And so somebody somewhere who had some very clear specifics about this was communicating this directly to a New York Times reporter. And the question is, where did this come from? And how do we find out where it came from? Well, we got to analyze the information. Who knows what? How do they know? What details do they know? Where did those details come from? And sort of backtrace the information. And that's what we're trying to do here. This is why Eric Nelson is submitting this with his documents over to the court, saying, "Listen, I had nothing to do with this. Okay, you can go find somebody else to pin this on. It wasn't us. We have no interest in doing that." And you can even confirm that by the information that I got in an email from a New York Times reporter. Go ask him where he got the information from. Here is the email itself. It says, "Hey, Eric, hope you're well. I'm reaching out because we are doing a story today about the upcoming trial where there's something I need to run by you to see if either you or Chauvin wish to comment. Piece is a broad look at the trial and the apprehension in Minneapolis about the proceedings because the possibility of unrest. Yeah. One part of the piece is my reporting on the details of the failed plea deal last May, right? And so if you're Eric Nelson, like, you know about this. But if you're us, you're going, what plea deal? Nobody ever knew about anything about this, right? And so Eric Nelson, if he's reading this, he's going, how do you know about that? Okay, you shouldn't know about this at all. So his spidey senses are ringing off the charts here. There's a problem. In my reporting, he says, this is what I learned. Mr. Chauvin had agreed to plead to third-degree murder, which would have resulted more than 10 years in prison. But at the last minute, AG Barr backed away. According to my reporting, Mr. Chauvin and his lawyer at the time, Mr. Kelly, had insisted the federal government sign on, so it was one big package. So Mr. Chauvin wouldn't in the future also face federal charges. My understanding of why Barr walked away was that he felt it was too early in the process and a full investigation hadn't been conducted. He worried that it would be seen as too lenient by the protesters in the streets, that at the same time, the state and Ellison were about to take over, and while the Freeman wanted to do this deal, Barr wanted to let the state make its own decisions about how to proceed. Please let me know if you wish to comment if there's any context you think I'm missing, even if on the background. If you prefer, here's the number again, right? That was a lot of information. Okay, that wasn't like somebody was just walking by the water cooler and heard that Derek Chauvin might be taking a plea deal because they saw a document that said Chauvin plea deal. No, this is very specific. Third degree murder, 10 years prison. Last minute, there was a back away by Bill Barr. He does a bunch of reporting. They said that Mr. Kelly, one of the other attorneys who's involved in the case, wanted one big package deal. And it wasn't just that, oh, Barr walked away. We know the specifics about it. We know exactly why. Full investigation hasn't been conducted. Too early in the process. Right? Might be seen as too lenient by the protesters in the street. So it's like somebody who's very privy to this conversation, like somebody who was at the table when they're having their round table, having a conversation about a plea deal. So who the hell is that person on the other side of the table there? Well, we're going to see if we can get down to the bottom of it. We have some speculation. This comes back from that Law and Crime article. Kang's motion more broadly accuses government actors of a wall of prosecutorial misconduct involving both the leak and other matters. It ascribes nefarious motives to Ellison for failing to personally participate in a court hearing after stating in an email that he would be personally present at the meeting immediately following a hearing from a motion that was filed by Kang. He says here, Mr. Ellison's late decision to absent himself from the hearing suggests he knew about and may have been personally involved in developing the strategy to cheat the defendants out of their rights to due process. Mr. Ellison distanced himself and did nothing to intervene or correct the course of the state's ill-intentioned ship. Ultimately, right, the buck has to stop with the AG. We're going to see where this leads. Now, the other important thing here is that the court is asking for these affidavits now, or presumably there's a motion that something's coming down the pike, right? Everybody's sort of saying, all right, let's see your cards. Let's show them, because things are, there's a lot of layers in this trial, and we're slowly starting to unravel them piece by piece. And the judge is now getting back to this issue. Oh, yeah. Hey, I know it's May 20th. I know the verdict's over, done, trial's over, but forgot about that New York Times thing. We're going to address that. I'll see you on Monday, and I want your motions in by Friday at 5. Right? Everybody's going, uh-oh, forgot about that. Shoot. All right, let's take some questions over from watchingthewatchers.locals.com, where you can support the show, and we love when you do. Here is first up in the house from No Doubt. Says, it seems like Eric Nelson should have filed a similar complaint about leaking the potential deal. Did he, or did he mess up there? So he filed something. Let's see if I can figure out what he filed real quickly here. We have a lot of stuff. So let's take a quick look at the... this is the docket from the court. And we have affidavits, affidavit of Voss, Nelson, verdict and finding regarding the aggravated sentence, notice of motions, and post-verdict motions. Yeah. So this is basically the closest thing that I think we got here, which was the notice of motions. Yeah, we went through this one, and I'm not sure if this included anything about proceedings, order the defense additional time to brief the issues. So this is just a notice. So see how long this is. This is 4 pages, and this is just a notice. So it's saying, hey, listen, we have a ton of stuff that we have in the queue. We're going to be filing phone books worth of motions. We're putting you on notice of this. And so this is something that happens a lot with appeals and post-conviction relief motions, is you have like a deadline. Say you have 14 days to file your notice of appeal. Oh, I just lost my trial. I got to let you know I'm going to be filing an appeal. This is just my notice. But then you got to get the transcripts. You got to get somebody to write the appeal. You got to review everything. You got to, the official recordings and listen to it again. And that takes a lot of time. So you just file the notice to get that buffer, and they'll say, okay, we'll file your actual appeal 90 days later down the road. And you say, great. Then you do all of your work. If you need an extension at that time, ask for one. Otherwise, you get it filed later. So I actually don't think I don't think we know the full universe of what Nelson is doing right now, because it's just too early. But we do know that he filed notice, and I think that there will be a lot more to come. Good question, no doubt. We've got Sharon Quidney's next up, says, how can anybody get a fair trial in a high-profile case with this kind of stuff going on? Misconduct, media interference, etc. Well, Sharon, it's not just a high-profile case. This is kind of in every case, right? This is something that defense attorneys are constantly complaining about, that the prosecution is overly biased, not as, ethical as they claim, and that they do a lot of things that are, marginal, borderline, or in that gray area. And that article that I was just going through from Law and Crime, if you want to read the full article, it's a good article. It is linked down in the, the slides are over at watchingthewatchers.locals.com, which has the link in the slides. But you can just find it, go to Law and Crime and search for what you saw, and it'll pop up. But my point is, it is, in that article, they were saying that maybe technically that what the prosecution did was not in violation of Minnesota ethical guidelines. So in other words, what they did is not illegal conduct. It's not unethical conduct. It's wrong. It's sort of questionable, but the rules in Minneapolis or in Minnesota allow for them to utilize them that way. And so if you utilize the rules to your advantage, are you really, are you cheating? No, because you're just following the rules better than the other guy. This has been, I think, what the Democrats did largely throughout the entire campaign, is they just followed the rules of the election better than the Republicans did, which is why they won. So, this is something that is, I think, pernicious. I think that a lot of prosecutors, a lot of courts, a lot of judges bend the rules here and there in order to move justice along. Hurry up, get out of here, right? Case numbers in manila folders rather than people. They just want to turn it into a processing plant, which is a big problem. And as we can see, sometimes, in the middle of a trial, you can't really see what is happening. You can't, you're sort of in the thick of it at the moment. But now we're starting to peel back the layers of that onion and see what really happened, maybe including some malfeasance from the prosecution's office. We have Sharon Quidney also says, this just bolsters the idea that the whole thing is a political show trial intended to promote the political agenda of BLM and CRT. It's not a bad take. We have a last one on this segment from Pato says, I just don't see why Eric Nelson would leak this information to the media. That would only make Chauvin look even more guilty and potentially put himself in hot water. If I had to guess, I would say the leak came from someone within the DOJ to give them good PR. Yeah, I mean, there already was a massive dog pile. Listen, if you're extremely cynical, if you are somebody who maybe, sort of imputes the worst motive to people, which many people would do for Eric Nelson, then you could say, well, maybe I'm not saying that he did this, so brace yourselves. But if you were conniving or overly cynical, let's say, you could say that Eric Nelson maybe leaked this information to the New York Times in order to sort of create an escape hatch for himself. So, somehow leak the information. Then when it gets leaked, slam your fist at the table and say, this is problematic, right? This is something that they did. So you're sort of framing the prosecution for doing something that was wrong and then claiming foul when they get caught, right? That would be a cynical way to look at it. I'm not saying that happened, but, attorneys do some shady stuff all over the place. If you're a practicing attorney, you probably get one of those magazines that comes every month that says, hey, it's Arizona Attorney Magazine, whatever. Nobody reads anything in it. It's filled with ads and everything. But on our magazine in Arizona, we have the discipline section. Everybody reads that section because we all just open it up and go, oh, why would you do that? That's so unethical. And we all just, go, oh my gosh. And, it's kind of how we police ourselves, right? Law enforcement, they don't really do that. You can go on the state bar website and look up any attorney. Oh, discipline, or a perfectly clean record. Can you do that for police? No, you can't. They get in trouble. Nobody even bats an eye. All right, so we're going to change gears. Thank you for all of those questions coming over from Watching the Watchers. .locals.com. I appreciate all of your love and support over there. And we're going to change gears and we're going to talk about Letitia James. Oh boy.